As a trustee, what's the best way to obtain a release from a beneficiary?
So in a lot of trust administrations, we have to figure out and get to a point where the estate can be closed, right? We want to close this trust administration, can't be open forever. And a lot of times trustees want to know that they can go home, go to bed, sleep well at night, and not have to worry about some future lawsuit cropping up from a beneficiary. So how is a trustee supposed to go about closing the door to legal liability once the administration's over?
That's a good question. And we primarily represent beneficiaries, but we do have a handful of trustees we represent. And what we found to close out an estate for a trustee is to send a very nice letter, a very transparent letter to the beneficiary saying the administration is now complete. We've paid off all the creditors. Here are all the creditors we paid off. Here's what's left over to distribute. Here are the trust terms. Here's our anticipated distribution. We're going to retain a small amount for any surprise bills that come up later, taxes or whatever. And that will be distributed 18 months after the first distribution. And what we say is we've included a release of liability in here. We'd like you to sign it, but you don't have to. In fact, you should go get an independent lawyer to advise you on this. But if you don't sign it, what I'm planning on doing is filing a full-blown formal accounting with the probate court, and I'm going to have them bless that. I mean, you'll be allowed to object to that too, but that's how I would get my true liability releases, to go to court and get a court to say, you, the trustee, have done everything you're required to do in this trust administration. So in other words, I'm empowering the beneficiaries. I'm saying, look, folks, I did a good job. I didn't do anything intentionally wrong. I've laid out everything to you in a transparent manner. You can sign the release. Ask me for any other documents you may want if you need anything to sign that release. If you won't sign the release, that's fine. I'll just go ahead and get an accounting. Now, you don't have to say it, but to go get that accounting is going to be an expensive proposition. And so the beneficiary has a decision to make, and that is, I've got a transparent trustee. They've given me mostly the information I would need to make a good determination here about whether or not I should sign the release or not. Or I can have the trustee spend a bunch of money on lawyers' fees and court costs, filing an accounting, and then I might feel a little bit better about it. So it's just, you leave it up to the beneficiary.
And the key of everything that you described there is that the trustee has fully performed almost, other than keeping a reserve in the trust. They've made full distributions. They've done what they're supposed to do. They're not demanding a release of liability before doing those things. That's in my mind, the most important part of everything that you discussed.
I agree.
Albertson and Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson and Davidson, LLP.